Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh, give their attention to the court now sitting.
Please be seated. Good morning and welcome to today's docket before the Kansas Supreme Court. We have one case on the morning docket. I will call it and ask counsel to please come forward and state their appearances. For those watching, just to, if anybody has tuned in to listen to the arguments in State of Kansas versus Edroy Taylor, that case has been continued and will be placed on our October docket. The case we will hear today is 123-379 State of Kansas versus Summer Duncan. Counsel, would you please state your appearances? Mr. Mann, could I ask you to come to the podium and state that into the microphone there? Thank you.
Hi, Mann of the appellate.
You're going to get really practiced at it today.
Thank you. May it please the court, Kai Mann of the Appellate Defender's Office, here on behalf of the appellant Summer Duncan, present and ready for argument. Thank you.
I'm throwing everybody off today by changing our protocol.
Good morning. May it please the court. The state appears by Assistant Solicitor General Jody Litvin, present and ready for argument.
Thank you, counsel. As counsel come to their chairs at the table, I will explain, they are aware, but to those who are listening, that Justice Standridge is not present in the courtroom with us today. She is under the weather and physically not up to being present, but fortunately she does feel good enough to be listening in. So she is listening to our arguments, to your arguments today, our discussions, and she will participate in the decision of this case as well as the case conferencing. I also want to explain to those who are not familiar with how the court functions that the court is generally familiar with the facts of the case. We have read the briefs of the parties. We have looked at portions of, not all of the record in the matter. You will see us at times looking at our computers as we listen to arguments today, as we take notes, we check our own notes, we look at various documents to help us understand and move forward with the arguments today. I say that just because I don't want anyone to feel like we are distracted and not paying full attention to the argument, because we are. With that, I will call to the lectern Mr. Mann to begin the arguments in 123096. Oh, I'm sorry, wrong case. 123-379. Thank you.
Thank you, Your Honor. Kai Mann of the Appellate Defender Office, here on behalf of the appellant Summer Duncan. Your Honor, may I please request 3 minutes for rebuttal?
3 minutes is granted. Thank you.
Thank you. And may it please the court. In Obregon, this court held the prosecution bears the burden to establish a defendant committed the version of the crime supporting the proposed classification. And while the PSI can often do this, the classification of a prior conviction is erroneous as a matter of law if the PSI does not indicate which version of the out-of-state crime the defendant committed. Remand is necessary in this case because the PSI does not indicate which version of the Arkansas crimes Ms. Duncan committed, leaving it unclear whether they are felonies or misdemeanors. Now, Ms. Duncan understands and recognizes that in Corby, this court held that an admission to criminal history at sentencing relieves the prosecution of its burden to support the accuracy of the criminal history score. Ms. Duncan asserts that Corby cannot control the outcome of this case for two primary reasons. First, the conflation of criminal history and criminal history score is legally improper. And secondly, Corby is factually distinguishable from this case in such a way that Corby cannot control. But I would like to start with the first contention, that dealing with the differences between criminal history and criminal history score. As I noted before, in Corby, this court said that when Corby admitted his criminal history, this relieved from the prosecution any burden to support anything more coming forward to criminal history score. But this cannot be the same thing because criminal history and criminal history score are two separately defined terms.
Counsel, can I
Yes.
just,
Go ahead.
can I just jump in and ask you, I guess what in my mind is a precursor question to where you're headed, which is, do the amendments to KSA 21-6814D change our approach to this issue? In other words, that amendment that imposed upon defendants the affirmative obligation to designate a record, does that change our calculus?
I'm not sure. That new subsection just came into effect in July, and there has been no, at least to my knowledge, no interpretation or precedent dealing with that, dealing with retroactivity. Because I mean, on the one hand, this is a type of a situation where a burden has been foisted upon the defendant, while we're already in this court, beyond all this litigation. And on the second hand, we still have this problem where 6814D talks of criminal history and not necessarily criminal history score. And as a third point and a separate point, we also got to remember that the definition of an illegal sentence includes a sentence that is ambiguous with which the manner and time with which it is to be served, Criminal history score problems where it's unclear as to whether the classification upon the horizontal axis of the grid is correct are necessarily inherently prejudicial, because unless we are absolutely sure of what that correct criminal history classification is, the actual sentence is ambiguous because that criminal history scoring controls the length of the sentence. So unless we have a definitive answer proven and carried by the state as to a correct criminal history score, I do believe we do have prejudicial error.
Is it fair then to say, to summarize your argument, at least with respect to the statutory language, the new statutory language in subsection D, it sounds like you're saying that because subsection D uses the words criminal history as opposed to criminal history score, that it's effectively not relevant to your case, to the arguments you're making?
I think that is one fair reading, and to the extent that there are multiple fair readings, I think the rule of lenity would kick in here to try to figure out exactly what is more favorable to the defendant moving forward. But I still think that even if it did affect this criminal history score problem, the issue in the definition of illegal sentence inherently makes almost every criminal history score question an illegal sentence, because it does render the underlying sentence ambiguous as to the time in which it is to be served. And so at that point, the remand is still necessary to get back there and figure out these criminal history score questions. Because it's interesting when we have this problem and you look at all the greatest hits of criminal history classification, Wettrick, Obregon, Buell, Moore, Dickey, all the greatest hits, we call these criminal history problems, but they're not. They're actually criminal history score problems. And the reason why we get a little bit loose with this language is because there are actually very few criminal history appeals. Usually the fact of a conviction is admitted, is taken into account, but the actual scoring, the legal question, the legal side of this is often very, very, very murky, especially considering when out-of-state laws and the differences between the various 50 states and how they classify things. So really, when we talk about criminal history, most of the time we're actually talking about criminal history scores.
So doesn't that cut against your statutory argument? In other words, if what you just said is true, why shouldn't we read the words criminal history in 6814D to be actually referring to criminal history score?
Because when we have a list of defined terms in 216803, I think that anytime we read into a defined term, then we're inherently changing 6803. And in fact, that would kind of destroy the distinction between criminal history and criminal history score as set out in the definition section of the statute.
Can I ask you maybe more of a factually oriented question beyond the legal standard and framework? So your client needs all three Arkansas convictions to be misdemeanors in order to prevail. Would you agree with that premise? In order for the criminal history, the criminal history score of D is the best scenario for you, right?
Candidly, Your Honor, criminal history score of C is the best scenario for us because Roberts took care of the misdemeanor
but-
convictions and we still have that Kansas.
Well, let me just say,
Yeah.
you've got 3 misdemeanors, Kansas misdemeanors that are aggregated, and that's 1 felony.
Yes, Your
right?
Honor.
Okay. And then, so you've got these 3 Arkansas convictions, right? And in the PSI, item number 7 reflects a conviction for possession of methamphetamine under the Arkansas Code 5-64-419.
Correct.
And if you look at that Arkansas statute, all possession of methamphetamine convictions are felonies. So why doesn't the labeling in the PSI of possession of methamphetamine why isn't that substantial competent evidence to prove the criminal history score?
Because it's our position that does not correctly identify, it's kind of like the other column where it says, AFN, without knowing the exact subsection and the exact crime that was committed and convicted of, we can't tell whether or not the rest of that is accurate.
Well, if you look at the statute, I mean, it breaks it down. I mean, you've got Schedule 1, Schedule 2 listed by drug types, methamphetamine. And when the PSI references the conviction under that statute for possession of methamphetamine, why isn't that a reference to the specific subsection? Because there's only one subsection that deals with possession of methamphetamine in that statute, and it identifies all convictions as felonies.
And I understand, but I think that unless the state is actually willing to give us the actual crime of conviction, I'm going to be very wary about trusting anything else other than that subsection, especially because this is how we get into the scoring. And you see this a lot more in the person, non-person stuff, but I need to know exactly what that conviction is so I can double check to see that these are accurately scored.
So that statute, there's only one subsection that references methamphetamine. And so you're saying that it's not reasonable to infer from the label that the conviction was for possession of methamphetamine, that it's not reasonable to infer that that's a reference to that subsection?
Correct. I am, because I think unless the state can actually give us the full information and not have to infer, we shouldn't have to infer that these things were done correctly. We shouldn't have to infer and guess and assume that the CSO found it.
And isn't that why there's a burden on defense counsel at the time of sentencing to raise that question? But we're on, and this is a challenge that's being raised for the first time on appeal. So that's why we get into this whole question of, well, who had the burden at sentencing, and why isn't, when the state comes forward with a PSI that has this inference in it, as Justice Wall is saying, and the defendant does nothing, why isn't that sufficient evidence to have carried the state's burden of proof? Even if had the defense counsel at the time said, whoa, I'm not willing to accept this inference. And now the state has a new obligation to come forward with journal entries or recite the subsection, but that didn't happen.
No, and I understand, but I think we're also conflating the difference between admitting to the existence of a conviction, which is a fact, and how that out-of-state conviction is scored in the state of Kansas, which is a legal conclusion controlled by 6811. And as this court has held before, you can only stipulate to questions of fact. We cannot stipulate to
There's
questions
no
of law.
legal dispute here. The dispute is over what specific subsection was your client convicted under in Arkansas. That's a fact question.
No, but the question is what she was convicted of in Arkansas for the purposes of scoring and determining a Kansas criminal history case. And as this court has said in Wettrich and many others, when we are dealing with the classification of a prior conviction, that's a question of law because it involves interpretation.
Right, but you're not, there's no dispute between the parties. Am I wrong about that? In other words, the defendant and defense counsel and the state don't have a disagreement about the legal consequences of which subsection client was convicted under. There's no argument. I mean,
correct, but the state failed their burden to prove that the PSI classified those convictions in a proper way.
Which is, okay.
In your answer to Justice Steele's first question, you in passing referred to the legislation that became effective this summer as shifting the burden. And I took that to be that you were making at least in passing, an argument that made it a substantive amendment, as opposed to a procedural one.
I've looked at that amendment several times, and to be honest, I'm I'm trying to figure out exactly how this works, because I do have another case where I've been arguing this amendment. And to be honest, I think the court could go either way. I think that this could be seen as procedural in the fact that it affects how the manner in which these criminal history scores challenges go on the first time for appeal. But I think it could also be substantive, because as far as I'm concerned, this was a burden that I did not carry until after the direct appeal was over, before the imposition. But prior to the 26814D, I believe that, myself and frankly, the rest of my office understood the state retaining the burden to prove beyond a preponderance that these things were done correctly until the direct appeal was over and we moved into, motions to correct illegal sentences or 1507s. So in that situation, it does kind of foist the burden upon the defendant on direct appeal, and particularly after, we're at the final stage of the direct appeal. And so I think it could be read to be substantive in that way. And also, I would also like to note that the state does have the opportunity also to present journal entries here. So if we accept my argument that that this is prejudicial error, because without determining exactly the correct criminal history score, the underlying sentence is ambiguous, then the state also has the ability to come forward under 6814 and provide their own journal entries, which they have not invoked up to this point, after the passage and effectiveness of 6814D.
And I note also, as Justice Wall said, that one of the convictions was for possession of methamphetamine. And since all possessions of methamphetamine in Arkansas are felonies, tell me why it would matter for purposes of criminal history score which felony was committed.
Because without identifying, the problem isn't which felony was committed. The problem is that the statute that is in the PSI contains both misdemeanors and felonies. Now, I understand that the CSO who prepared the PSI put down possession of methamphetamine, but that's not good enough. You have to let us know the exact subsection that they were convicted of so that we can go double check, because a lot of times these things don't match.
Except there was a stipulation to a conviction for possession of methamphetamine.
I actually dispute that, Your Honor. If you go to the sentencing transcript and volume 13, at 3 to 4, the court only asked Ms. Duncan if she had reviewed her criminal history as set forth in the criminal history worksheet, and do you have any objection to any of the convictions? And she said, no, ma'am. Now, I understand that during the argument of disposition, but this court has said over and over that arguments of counsel aren't evidence. And this classification has to be supported by substantial competent evidence. And that's just what we don't have in this case, is substantial competent evidence. So basing this on the statements of counsel, and I'll also note too, I don't think that the Court of Appeals, I think the Court of Appeals read a little bit too much in to the statement of counsel. You can find it at page 5 of 13, where they said that counsel indicated that all three were methamphetamine related. Now, I don't read that at all, because the counsel stated she picked up a possession here in 2017 and had possession of methamphetamine charges and possession of drug paraphernalia in Arkansas prior to that point. So even if we do take that to the possession of methamphetamine, which I still think we shouldn't, because it's nothing more than a remark of counsel,
But
that doesn't necessarily state that the paraphernalia are involved with methamphetamine. She could have had, a couple of marijuana pipes, but we don't know, because the actual subsection has not been provided to us.
I'm sorry for interrupting.
Oh, no, I'm sorry.
But isn't the PSI report evidence?
The PSI just identifies a statute that contains both misdemeanors and evidence. And
No,
frankly,
the report itself, the document, the PSI report that is presented to the court as a document, isn't that documentary evidence?
it sure can be, but I also think we also need to take a look at 6813 and see what's supposed to be part of the PSI here, because 6813D clearly states that the criminal history worksheet will not substitute as a pre-sentence investigation report. And 6813B5 says that any documents or journal entries or other things obtained in creating the PSI shall be attached. I have never seen a PSI with documents attached, yet we have these source of informations as being these county courts. So, I mean, had the state actually followed through and followed 6813, probably not here, but they haven't, and they haven't provided the subsection. So frankly, if the state would do any of these things, this would be taken care of, but they don't. And so I'm here arguing basically to get the state to do the things that the statutes require them to do.
I'm going to push a little bit. I understand that you say the PSI report can be evidence, But isn't it evidence actually without objection?
No, no, Your Honor, I disagree, because if we look to the actual language of 6814, you say the offender's criminal history shall be admitted by the offender or determined by preponderance. Ms. Duncan did not admit. Ms. Duncan did not object, but Ms. Duncan did not admit. This is very different than Corby and Roberts, where you had an affirmative, yes, Your Honor, that is correct.
No,
All we have
that's-
here is a failure to object.
That's in response to the question. That's separate from the document.
Well, I think the PSI in this form does not provide the evidence, because there is no way where we can actually go and identify those actual convictions without relying on some sort of hearsay that's in there. We can't independently verify this. We're just putting ourselves at the mercy of the CSO. And again, like, I have another case where the conviction was listed as a municipal misdemeanor in a jurisdiction that doesn't have municipal ordinances. I mean, I think we're putting an awful lot of unwarranted faith in these PSIs, and I see this a lot. I see a lot of mistakes here, and I don't think that it's too much to ask for the state to give us the full subsection. I mean, they got the statute. Why can't they get the last, just couple pieces of that? I don't know what kind of records you're looking at. They're going to have the statute, but not the subsection, because the subsection is really the important part here. That's what really tells us what this conviction is. And without that, and without attaching any of the other documents that we can figure out how they figured this out, then no, I do not believe that the PSI in this case satisfies the state's burden per Obregon.
Is it correct to just summarize your position as this is Obregon?
Yes.
I mean, and
Yes.
Obregon said, when there's two versions within a statute, if the PSI doesn't indicate the subsection, that's not enough.
Correct.
To satisfy the state's.
Yeah,
burden. That's where you're at.
At bottom dollar, that is where I'm at.
And then following up on that, your position would be that the statutory amendments that took effect this summer do not change the holding of Obregon.
Correct. See, I've been out of time for a while. I apologize.
I think our questions are what took you there. So thank you.
Thank you, Your Honor.
Litvin?
Good morning, may it please the court. The state appears by Assistant Solicitor General Jody Litvin. I had 3 points to make today, and I think the court has hit on all of them already. So I will start with the amendments. That was going to be, well, actually, I'll start with the appellant has stated that she is really challenging the criminal history score of C. But then I heard counsel today just get up there and say that the criminal history score, the best criminal history score that we can end up with, even if we take out the Arkansas convictions, is C, because we still have a Kansas non-person felony. So I'm not sure how we have an illegal, an incorrect criminal history score of C when there was just an admission that even taking out all of the Arkansas cases, we still have a adult person felony from Kansas, possession of meth. So we still have a C. So I think we can end there. That's one of the options. Second option is going to the amendments. I think that does change the course or the approach to this issue, because I do think that the defendant now has to show that there's prejudicial error. And I also think there's another statute to look at, which came out in July, which is 6820 subsection I, which states the sentencing court shall retain authority irrespective of any appeal to correct an illegal sentence or clerical error pursuant to 223504. And I think that if there really is not just a hypothetical error here and a real error, even while this appeal is pending, the appellant could have gone down, or the defendant could have gone down to the district court, presented the evidence, and had the criminal history fixed. So why we're still in front of this court approaching this issue for a remand when that could have already been done since July? The state questions why this court, is in the best position to do that when relief really is at the district court, and appellant and defendant could have already done that. So I think those statutes do change the approach. And again,
Counsel, what's your best argument for applying the 2022 amendments retroactively?
well, 6820J says that they're procedural in nature and shall be applied retroactively. So we have a subsection in there, that statute. As far as the other one, 6814D.
Yeah, that's what I'm referring to.
I mean, I hadn't really thought about that until today. I
Because
think,
as you just said, the legislature knows how to say
They do.
retroactive, and they didn't do that here.
correct. I think it's procedural because although it changes the nature of the criminal history classification, it's procedural in that it's just showing that that they have to prove error.
I think I would agree with the general proposition that this court has held that changes in burdens of proof are generally procedural
Yeah.
in nature. But I'm curious to hear your reaction to opposing counsel's suggestion that when what is happening here is a change of what amounts to a burden of proof on appeal, and the statute went into effect after the appeal was perfected and all the briefs were filed and so on. So there does seem to be a tension there with, well, how in the world is the defendant's not on notice and defense counsel's not on notice. So they file this appeal and now we've got a change of burden of proof, but it's too late to go back because they've already made all their arguments. There's a preservation problem essentially. How do we handle that? Does the defendant get to file supplemental briefs raising these new arguments or try to actually supplement the record to satisfy the statute? I'm just curious what your thoughts are.
I don't know that it's a preservation problem because it came up mid, this appeal happening. And I was thinking about that and could I file a 609 letter, but it's not really an issue that was raised earlier. So I don't know that it's a preservation problem, but supplemental briefing might.
Well, the statute says the defendant has to designate a record, but it's too late. It's too late for the defendant to comply with the statute.
Well, to designate a record, they would have to get it filed within the district court. And I don't know that there's anything prohibiting if you had documentation to file that with the
In other
district
words,
court and
you
get it
don't think
added.
the rules, our appellate procedure rules would interfere with that
I don't know.
possibility?
I don't know. I think I've had things added to the record during the pendency of an appeal. And certainly if this was true and there was a mistake, I don't think the state would raise those type of, objections. This is beneficial to everyone to have someone's criminal history correct. So I just don't think there would be a fight over someone wanting to get something added to show that. In fact, I think we'd want it to happen more quickly than waiting throughout this whole process.
It's appropriate for judicial notice.
If they had journal entries or,
A journal entry of a prior conviction.
I think one of the statutes allows for Kansas convictions for the district court to take judicial notice or this court to take judicial notice. I don't know that it allows for out of state, but again, that's certified documents. I know that the state though has fought over that for a while, getting things like this before this court. So, yes, I think it would be appropriate. And I think the last comment I had was just to say that the Court of Appeals, if we're going to get to the outcome of the Court of Appeals, the state's position is that they were correct and that this case is distinguishable from Obregon and more in line with the Roberts and Corby line of cases.
How is it distinguishable from Obregon?
The admission.
Well, so can you point us on the record to the place where it would demonstrate that what Mr. Mann argued is incorrect? Because we heard the argument that there was no objection, but there was also no admission.
And I guess the state would disagree with that.
Based on what?
We believe that it was an admission. I'll read from the transcript from volume 13, page 3. And Ms. Duncan, have you reviewed your criminal history as set forth in the criminal history worksheet attached to the PSI? And the state's understanding is that would be this supplemental criminal history worksheet section where all of the convictions are listed, statute numbers without subsections, conviction code, classifying them as felonies, misdemeanors. And she says, yes, ma'am. And do you have any objection to those convictions listed in that document? And she says, no, ma'am. Although,
no objection.
right. I think that that's an admission to, I have reviewed these convictions with everything listed and I don't object to them, which is saying that they are correct the way they are. So I guess we just disagree on that language. And I realize it says literally no objection, but I think we just disagree. And then based on that criminal history, we will find that you have criminal history score of C. And then I agree with the defendant in saying that later what they're using for the departure motion and talking about the possession of methamphetamine is not evidence, but I think that goes to bolster the fact that she, that this criminal history is correct, that it was for possession of methamphetamine and that the paraphernalia was for methamphetamine as well, because they were arguing for drug treatment and arguing that she was a methamphetamine addict. So I think that just bolsters, although it's not evidence, I think it helps show that the criminal history score and the criminal history classification is correct.
I'll point it out that the PSI report does say possession of methamphetamine, all possessions of methamphetamine, the Arkansas statute, regardless of subsection or felony. Does it matter whether it was a person felony or a non-person felony for purposes of criminal history score?
It generally, yes, I mean, person felony versus non-person.
I mean, in this case, does it matter? For
Well, if it
purposes of
were,
saying it was a C.
if it were a person felony, that would bump her up.
Does it say on the PSI report that it's a non-person felony?
Yes.
So that part of it is not contested either. Non-person part of it.
I don't think so. I think it's the felony versus the misdemeanor distinction. And that if these were all misdemeanors, not be a criminal history score. Well, she would be a criminal history score C since we still have that Kansas Kansas non-person felony. But I think the outcome that they are wanting is for all of those to be misdemeanors. But I do, and I agree with what Your Honor was saying about this is evidence. This document is evidence. And when you don't object and when you admit to it, that meets the state's burden.
So it's admitted as any other exhibit is documentary exhibit is admitted by the court for consideration.
Yeah, that's the state's position.
Go ahead.
Stating that you have no objection is not a stipulation. If we would accept that, at least it adds to the preponderance of the evidence, which is the burden that of proof when we're looking at what is the criminal history.
Yes. And again, if there was an objection or anything, when you're asked to look at the specifics of this criminal history worksheet, which do not include subsections and include that classification code or conviction code, and there's no objection to that, yes, I think that can be evidence that can go towards the preponderance of the evidence.
Do you have a position on whether the correct procedural posture of this appeal at this time is to basically pause this appeal and give the parties the opportunity to flesh out the new subsection D, 6814D? Have the defendant make a showing of prejudicial error and follow from that?
I think that could be an outcome of the case. I think that could also be done at the district court. We're not without a remedy if this court decides to affirm the Court of Appeals opinion. I think the defendant can still go to the district court for relief, where it's probably better and you can have a hearing, evidence presented, and then determine.
If 6814D is applied retroactively here, maybe my question goes to the definition of prejudicial error. If we agreed with your opposing counsel's argument that this is Obregon, and essentially there's not substantial competent evidence to support the criminal history score, is that prejudicial error?
The fact that the state didn't meet its burden.
Correct.
I would say that the prejudicial error would be the mistake in the the incorrect part of the criminal history. The prejudicial error would be showing that these were misdemeanors. So going to the actual classification.
And I mean, I don't know if that term I don't see a definition of it, but generally common definition is error substantially affecting appellant's legal rights and obligations. And it seems to me if you are, your sentence is based on a criminal history that lacks substantial competent evidence, that would seem to be prejudicial error under that definition. But I didn't know if you had a different definition. I understand your argument that no, you have to actually demonstrate that the score would have changed, in other words. And I didn't know what you would rely on for that construction versus a more general definition of prejudicial error.
At this moment, I don't have anything to point to you. But I mean, I think what makes it prejudicial here is the incorrect score. So, and it's the length of the sentence that would change. And also, I mean, here, do we really have prejudicial error when the score remains a C, despite what happens with the Arkansas convictions?
I was going to ask Mr. Mann this question, but I think I know the answer to his answer. But is there a difference? It follows up on what Justice Wilson was asking about the distinction between showing whether it's a non-person felony versus just showing the distinction between a misdemeanor and a felony. Is there a difference in the state's burden to show that at all? We have different rules for when we apply the non-person. We go to the statute, we look at it if it's broader and all of that. Do the same kind of rules apply when we're looking at the distinction between felony and misdemeanor?
As far as out-of-state crimes, I would say, yes, they're different. And I would say that Obregon has a very narrow holding to allow for, in a Wettrick issue, to go to that divisibility and to figure out which subsection applies. And here, I would consider that to be a different analysis than Obregon.
So if I understand what you're saying, a felony in Arkansas is a felony in Kansas. You don't need to know anything else.
Yeah, you go by the convicting jurisdiction. So they determine whether that's a felony or a misdemeanor. I don't believe I have any other presentation.
Questions? Thank you. Mr. Mann, you reserve 3 minutes.
And may it please the court. First, I just wanted to jump in with a couple of things that counsel argued. Adding things to the record to show a defendant has an illegal sentence is not easy. I've been trying in a separate case for over 2 years. I've petitioned this court and had it denied trying to add it. So no, the state does fight these. I appreciate that the Attorney General's office generally doesn't, but the state does fight these very difficultly. And I've been having a time with this. So for one, I don't think we should rely on the state being magnanimous enough to admit their mistakes and do this, because so far I've been having a difficult time with that in separate cases. Secondly, the definition of an illegal sentence is a sentence that is ambiguous with the amount of time to be served. Criminal history score determinations directly control the length of the sentence. If the state fails their burden to carry it at sentencing, that does not become the defendant's problem on appeal. The state simply failed their burden. That is prejudicial. The state not doing their job is prejudicial, even if they accidentally get it right. I think that the bigger point here is that these things have been done incorrectly for a long time. And until the state is forced to redo them and do them correctly the first time, they're just always going to be done incorrectly. And they're always going to be having this fight. So I do believe this is a bigger problem here. And at the end of the day, an ambiguous criminal history score results in ambiguous criminal sentence, and therefore it is prejudicial error. And again, since the
How is it prejudicial if they happen to be right, but just didn't prove it up the right way?
Because we don't know it's right until it's done. Anything else is just
How do we know it's
assuming.
prejudicial then? I guess it's
Because it's ambiguous, because we can't tell. If we can't tell and it's plausibly both, then that fits the definition of an illegal sentence as ambiguous. Like if I have one misdemeanor that may or may not be a misdemeanor, right? It may not be able to be scored at all. I am plausibly an H and an I at the same time. And so unless the state is going to go through and carry that burden, I have prejudicial error because I don't know what my actual sentence is.
Tell me, Mr. Mann, how it would be prejudicial if we know that you're a C and we know that there aren't enough person felonies to make you a B. So you're in the C box, but we don't know whether you have 3 more non-person misdemeanors and some non-person felonies. We don't know exactly how many of those there are, but we know it's not going to put you in a B.
For,
Then tell me, in that scenario, where's the prejudice if we don't know those things that aren't going to change the criminal history?
two things. One, in this particular case, sorry, excuse me. In this particular case, again, I admit that we're a C regardless of what this court does. I was a little bit surprised when this petition got granted because of that fact, but that's just where we are in this case. But, you know, as the bigger point, the state has a burden to prove these things. And the longer we keep on letting the state off the hook to actually prove these things don't get proven, and we spend more time up here doing these. If you look at 6813, a lot of these things could be headed off if the actual things they got to classify these things are attached and everybody could see them, but they're not.
Okay, I understand that point, but let me reel you back in to what I'd like you to focus on. Why does it matter if we know you're in criminal history score C? Regardless of what these ambiguous things tell us, which may be misdemeanors, may be felonies, but it's not going to change the criminal history score. Tell me how your client would be prejudiced in that scenario.
And again, Your Honor, in this case, outside of the state, and again, I know we've gone this, outside of the state failing to fulfill their duties at the district court, which one I think is error that needs to be corrected anyways. Two, in this particular case, again, I admit that we're going to be a C regardless where we are. But to the extent that this raises any mootness issues, which hasn't been discussed at all until now, this is an issue of statewide importance.
It's not moot. I'm looking for prejudice. How are you prejudiced?
Again, I think that the fact that the state fails to do what they're supposed to do in district court is borders on the denial of due process. And I think that is prejudicial. I understand if there's a disagreement, if the overall sentence doesn't change, but I think that there is always harm when the state does not carry their burden and does not do their job at the district court.
Why are we at a C no matter what?
Because the three misdemeanors, Roberts has basically taken out the legs of that
Right.
argument, which makes person felony. And then the Kansas methamphetamine,
Kansas non-person.
yeah, was not challenged.
And those were proved up.
They were not challenged in the Court of
And
Appeals.
even on appeal, you have no objection to the proof of those.
Correct.
things. So then I guess the question is just, didn't the state then satisfy its burden to prove C?
The state satisfied their again, you know, we have no, again, that's why I was a little bit surprised to be up here on this case, because it doesn't change regardless. But yes, in this particular case, the state, that we have no objection with the C, given the way everything shook out. But we do have objections with the way these criminal history scores are handled in district courts generally.
Okay.
And with that, I have no more remarks, but I'll answer any questions.
Thank you, Mr.
All right,
Mann.
thank you.
Thank you to both counsel for your arguments in this appeal. We will take it under advisement. Court is now in recess until 9 a.m. tomorrow morning.